think there are misconceptions about the TCF, and sort of bigger things are attributed to it than what it actually delivers. It's actually a quite narrowly focused solution that enables a website to establish a GDPR legal basis or e-privacy access for ad tech companies, or indeed any partner company working to support, in our case, delivering and measurement of digital advertising on a website, but it also covers personalization, personalization of content. So it just enables the instance that has the interaction with the user to ask for permission on behalf of these other instances to establish, to take users' choices, provide the necessary information required by the law to enable users to make choices, and then it captures those choices and shares those choices with companies that the user will have authorized. Well, the question of whether we're a data controller or not really gets to the heart of whether an enforcement action should have been brought in the first place. And it's about whether the GDPR actually applies to a trade association as such. And it's a question that has really major implications for any standards organization, not just in digital advertising, but in all walks of life, where you have trade association or other body that puts out an open standard under the interpretation of the law that the Belgian DPA has taken. That standards organization would take on legal and financial liability under the GDPR that we're pretty sure that the law wasn't intended to place on them, and that might pose a sort of existential challenge to the way the development of open standards has worked up to now. So the TC string is just the signal, really. It's just the digital string that captures the choices that the user made. So TCF presents certain information required by the law. User makes choices based on that information. Maybe they say, no processing of my personal data for any reason. Maybe they say, I'll take profiling, I'll take measurement. TCF has like 10 purposes. So the string is just just captures the user choices, and because like users, millions of users make billions of choices on a very limited set of options. TC strings aren't unique, and so couldn't be used to identify you, and oughtn't to be subject to the requirements of the GDPR sort of as such. The importance of whether the TC string is personal data is also partly to do with the earlier question about whether an enforcement action was appropriate in this case, whether a trade association should be the object of an enforcement action. If you are a data controller, you need not only to be a data controller, but you have to be processing some personal data, and the TC string is the purported personal data that the litigation chamber, Belgian authority, landed on as part of the qualification of IAB Europe as a data controller, which, as we've said, we believe doesn't align to the law, to the structure and meaning of the law. I think so on the issues of the merits, whether legitimate interest is an appropriate legal basis for profiling, whether the TCF purposes are sufficiently clear and sufficiently complete, the court has kind of parked its reflection on those things. But it's come down on some procedural issues, and it's referred some questions to the European Court. But the procedural issues actually have some substantive import to them. In the procedural findings, the Market Court has challenged the way the Belgian authority came to its conclusion on the issue of whether the TC string is personal data. So that casts a shadow of doubt on a really core foundational part of the decision. It seems so that in combination with the fact that these really foundational issues, are we a data controller, is the TC string personal data, have been referred to the court, to the European Court. Those in combination make it seem pretty certain that no other data protection authority, nor indeed the Belgian authority, is going to bring a case based on that decision, even if the decision hasn't been formally suspended, which it could have been. The Market Court could have suspended it, but they didn't, and so it's sitting there in theory, but it's somehow tainted by the procedural finding. And so an authority could bring a new enforcement action against a publisher or vendor based on a new investigation, but that's a risk that everyone lives with every day. The law's been in place since 2018. Companies are supposed to have been complying. At any moment, someone could challenge your use of legitimate interest as a legal basis for profiling, or say that some other aspect of your UI doesn't conform to their interpretation of the law. So I think that in that sense, there's some reassurance with the current set of circumstances.